Hi, I'm Gary Finklea, an attorney from Florence, South Carolina. I would like to talk to you briefly about what happens to your property when you pass without a will. Oftentimes, I have many clients come into the office and think that if I pass without a will, then my property will go to the state of South Carolina rather than my family. And that's a common misconception. Some people think, well, if I die without a spouse or children, that will happen. Again, that's a common misconception. In my, think how many years I've been practicing law now, 20 years of practicing law, just about. I've not seen one occasion where property has passed to the estate. And the fancy legal word for that is a sheet, E-S-C-H-E-A-T, a sheet to the estate. And that is just never happened in my experience, and rarely ever happens. But the General Assembly's passed a statute to provide for what we call intestate distribution. If you die with a will, you're deemed to have passed testate. If you pass without a will, you're deemed to have passed intestate. Therefore, if you pass without a will, we look to the statute that the General Assembly adopted to determine how your property should pass. Now, generally we find that this statute is fair and reasonable, and oftentimes is what a testator would want. A testator being the one who drafted the will or makes the will would want. Let me give you some examples. If you pass with a wife and no children, your wife would receive 100% of your estate. If you pass with a wife and with a child or children, your estate would pass half to your wife and the other half to your child or children. If you have two children, those two children would share one half of the half, or 25%. If you had three children, each child would therefore split half of your estate three ways, and so forth and so on. Now, if you pass and you've never been married and you don't have any children, your property passes upstream, back up to your brothers and sisters. In the event that one or more of your brothers or sisters passed, their surviving heirs will receive your brother or sister's half. If you don't have any brothers or sisters, it goes up further, back to your parents. And more than likely, your parents would have predeceased you, but sometimes parents do take. And if your parents are deceased, predeceased you, then it goes across to your aunts and uncles. And if any of them are alive, they take. If they don't take, then their children or grandchildren below them take. And it goes on and on for a few more generational levels. So you can see that rarely ever does property pass to the state of South Carolina. I've only had one case really where property has really passed a few generations, and folks inherited who probably, or in fact, didn't even know the person who died. We call those folks laughing heirs, and that does happen sometime. But that just goes to show you that it's the legislature's intent that some family member receives property more, or gives the family member, even distant, greater preference over the state of South Carolina. Now, one other thing to consider is, if you don't have a will, is who serves as personal representative. Again, the legislature, in their wisdom and in the statute, listed the priority of folks to serve. And you begin with your spouse, and then after the spouse, your children, then your parents and other relatives. It's a very wise statute, and it goes what you would think to be who would be your closest relative. Now, even though we have the intestacy statute, it is oftentimes advisable to get a will. First, if you want to alter the intestacy distribution or intestate distribution, you need a will. Second, if you want to specify who your personal representative is. Next, if you want to provide some testamentary trust for minors who receive property. If you want to restrict the use of property, or sometimes what some folks call entail, E-N-T-A-I-L, property, basically means tied up for a while. you need a will. So my suggestion to everyone is, though you don't absolutely have to have a will, it is always preferable to have a will. Another important thing for parents is you can name testamentary guardians for your children if you would happen to die while they were still minors. So many benefits and uses of a will. Now, at Finklea Law Firm, we prepare wills primarily as a service for our clients. It's not something we make money on, or we do try to at least break even on, but generally, with the time involved in speaking with folks regarding all these needs and estate planning issues, we lose money. But we charge $150 for a simple will, and then for a couples, we reduce that to $250. And when we talk about wills, we go into other areas of estate planning, and I'll mention those to you in another video. Thank you very much.